I commend this bill to the House.
Andrew Little.
Thank you, Mr Speaker. It's a pleasure to stand again to talk on the Laws and Conveyancers Amendment Bill. And, sir, like my colleagues on this side of the House, the thing that is overwhelming about this bill is just how disappointing that in a world where all around, in many other countries, conservative and progressive governments are looking to changes that actually progress the human race, when they are looking to do things that might be rooted in the values of the old, but they're changing the practices of the past. And here we have a piece of legislation that does the opposite. It reinstates the practices of the past with no real values attached to it at all. This bill does a number of disappointing things. Reinstates the Queen's Counsel name, and make no mistake, sir, as a member of the profession, the legal profession, I think it is good that, at least in the profession of law, the practice of the law, we do develop a profession, a body of people with a set of values, with a set of principles, and with an approach who play a very important role. But also understanding that part of developing a profession is that you recognise those who are top performers in it, those who are stellar performers, and you do accord some status to it. And so that those coming into the profession know what good performance looks like at the bar and have something to aspire to, know who the good performers are. And likewise, those on the bench who are dealing with counsel all day, every day, can rely upon those who have achieved a certain degree of skill and indeed notoriety in some cases when they appear before them. So the profession understands it. And so conferring some sort of name or title or rank on the senior practitioners in this very important field, and a field which, as I submitted the other day, is one of the bulwarks against a rampant breakdown of the rule of law and an undermining of democracy, it is appropriate that we confer some sort of style upon those who are the top performers in it. But when we hanker to the colonial relics of the past and reinstate the Queen's Counsel title, that is what is so unnecessary. If the government is serious about going back to the past, here is another relic from the past that we might consider. You see, counsel, when they are appearing at the bar, certainly at the senior bar now, and wear their gowns, carry on the back of their gowns a little pouch. And the background to the pouch was that senior members of the profession, it was beneath them to ask for money for being a good advocate and a top advocate. Were that to be the case today, sir, life may be a little different. But they did not ask for a fee or to be paid, but the pouch was there so that the happy client, irrespective of the outcome of their proceeding, knew that they had a duty to reward their counsel, who had put themselves in some cases on the line, risked a beheading by the Queen of the day or the monarch of the day, and so as the counsel was cleaning up their desk after a hard day's advocacy at the Chancery or the Admiralty Bar or the Assizes or whatever court it was that they were in, a few ducats or golden ducats or guineas or coins would be placed in the pouch, and the client would wander away, and it would be seen by counsel as an anonymous contribution and a fee for their work. Well, that's not the way it operates today. Of course, one engages a QC, as I know at least one member of the House has recently, and I enjoyed his company yesterday. QCs don't do that anymore. They don't wait till somebody fills up the pouch in the back of their gown. They send an invoice. And when you carry the rank of QC, of course, that invoice frequently has several zeros on it, and that is before the decimal point and the two other zeros that follow after it. And that is what it has become. Now, in this day and age, the legal profession, like many others, but apparently not the accountancy profession, has changed significantly. And top performers don't always practice, at least are not always barristers sole. Many do stay. For many of the top performers in our legal profession are in the firms. Or they set up their own firms and they don't want to have to partake of the intervention rule, so they retain their style as a barrister and solicitor. so that they can take clients directly, which is a quite honest transaction. There are some barristers sole who, for whom the intervention rule is really a formality that they honour in its breach. But, sir, the legal profession has changed, and our top performers come from all parts of the profession. And some of them, they are employed solicitors, they're employed by corporations, they are the general counsel of large companies and large corporations. And indeed, I might say, even in 1 or 2 trade unions, there are top performing lawyers in the profession. And so there is no reason why the top performing members of the profession, irrespective of where in the profession they practice, should not be recognised if they are regarded by their colleagues across the profession and the members of the bench. They should not have a recognition of their excellence and of their and of the performance that they can achieve for the clients on whose behalf they act. And that is why it is so unfortunate that now the conditions upon which one might acquire that style or that label that will indicate and mark them out as a senior and excellent practitioner is now going to be so restricted and confined. Now, it does limit it, and it limits it for not just for men, but for the women in the profession as well. And let's face it, we are desperately short of women who have been recognised by the profession as being top in their rank. That is so disappointing, and it is so unnecessary for us to hanker back to the past and maintain those colonial relics. And then, of course, there is the provision that allows the royal prerogative to be exercised, which, as we know, under the Constitution Act and other provisions, is done upon the advice of the government of the day, the cabinet of the day. And so it is not a genuine royal prerogative. It is the prerogative of the government of the day, and that allows the government to recognise anybody, not just those in the profession, and the legislation marks out that those who could be conferred, have the style conferred upon them, don't have to be at the bar. But the royal prerogative provision in this bill allows the government to confer it on anybody. Now that is really, for a bill that claims to be acknowledging and recognising the excellence of the profession, really is beyond the pale, because it takes it outside the profession and it makes the judgment of who is recognised by the profession as excellent and as warranting that sort of recognition. It takes it out of their hands, and it really undermines the very purpose for which the bill says it is there for. And so, sir, that is what makes it so disappointing, that not only does it restrict now the number of people and the positions from which they practice their profession and prosecute cases on behalf of those who need their help, it also, and who are genuinely deserving of the recognition, it actually allows the government of the day to ignore all of that and for their special friends to confer this title. And that is simply uncalled for. In the modern age, we want the best performers to be recognised, and we shouldn't have to impose unnecessary and irrelevant conditions, such as that they practice as barristers sole, practice at the independent bar. Because this is the other thing about the independent bar, the point I made the other day. There are members of the independent bar for whom the independence is nominal. They are embedded in corporations, they are embedded in organisations on whose behalf almost exclusively that they act. And I could name examples, but I don't care to, sir, and so there is a real question about that. They apparently would qualify for this recognition, but those who happen to be in a law firm, top partners in a top law firm, who do excellent work for their clients, who are excellent counsel, recognised by the bench as that, they are disqualified from being recognised in this appropriate sort of way. And in the modern age, that is unnecessary and uncalled for. And so for that reason, we are opposed to the bill. It'll be a giant leap backwards as the profession starts to take charge of improving its standing and its internal professional regulation and management. And, sir, we are voting against the bill for that reason.
Alfred Naro.
Thank you, Mr. Speaker. I stand in support of the Lawyers and Conveyancers Amendment Bill.